Now we get to look at a torts hypothetical that tests many of the issues relating to land. So here we get to review some law where the law of torts brushes up against the law of real property. Take a look with me at the call of the question. What are Howard's rights and remedies, if any? Discuss. Well, that's a fairly oblique call of the question, but I can give you some ideas about what to do on an essay when you get a question like this. Obviously, we know that this guy Howard is going to have one or more theories of liability, and he's also going to have one or more prayers for relief. Now, thinking like a plaintiff's lawyer, this plaintiff Howard is going to sue everybody else in the question unless we get some good guidance about who the real defendant is. So, with Howard carefully in mind, we go to the top of the question, and we learn about refine. And look at the very first sentence. Why do you think it is that they would tell us how long refine has been engaging in its activities? Almost certainly because they are bringing up a nuisance issue. So, with regard to Howard, we can guess right up front that almost certainly he's going to have a cause of action for nuisance just based on the first sentence. We learn about this smelter in Zone A. We also find out about the crushing of ores, which creates noise and dust. This would be further indication of a nuisance. We learn about zoning and about the fact that the refinery is in compliance with zoning. And by the way, zoning is an area where the law of torts and the law of real property and constitutional law can all touch one another. And we find out about the new subdivisions that were just opened last year. So clearly, anybody in this subdivision may be bringing a nuisance action, but they're going to have a coming to the nuisance defense, as well as the fact that this defendant is in compliance with the local zoning ordinances. In paragraph 2, we find out about the residents' particular concerns. The refinery uses trucks that carry toxic chemicals right along the border of the subdivisions. And they are also concerned about the fact that the containers that contain these toxic chemicals are vulnerable to stiff winds. And we find out that 4 homeowners suffered burned lawns as a result of an incident involving these chemicals. Now, let's take a quick step back here. We have just learned about something new that the refinery is doing, transporting the chemicals. That conduct probably could give rise to a strict liability theory. When you think about it, toxic chemicals that can burn property could be considered ultra-hazardous. That doesn't necessarily mean they are, but certainly thinking like a plaintiff's lawyer, we will be interested in pursuing strict liability. And remember, strict liability is really a stronger theory for a plaintiff than negligence, because to establish strict liability, the plaintiff need not show that the defendant is at fault, whereas in negligence, that's necessary. Now look at paragraph 3. We find that the refinery has yet another course of conduct that's giving concern to the community, and that's dealing with toxic waste. They bury them, and the containers that the chemicals are buried in disintegrate after 15 years, and that poses a threat to the subdivision's water supply. And that's the sort of thing that justifies injunctive relief, because the permanent destruction of a water supply almost anywhere is a cause for concern, but in an area which is being used by residents, it is a particularly heightened concern. Now, we learn in paragraph 4 that residents have urged the city itself to bring suit against the refinery. And what would the theory of liability be for that lawsuit? Answer: it would be public nuisance. But the city won't act, or at least so far it has not yet acted. Now Howard, one of those who has been urging the city to take action, and one whose lawn was burned, has sued refinery seeking damages and equitable relief. So we know what the prayer for relief is. This guy wants money, and he wants injunctive relief. Now, let's pause for a moment. We see now that this question is only about one lawsuit, the lawsuit between Howard and the refinery. We've got facts in the pattern that support both public and private nuisance actions brought by this plaintiff. He suffered a special harm. Since the city is unwilling to intervene, this guy Howard will be allowed to. Now, this is the sort of question that is testing our ability to come up with as many theories of liability as possible. When we've only got one lawsuit, we're expected to go into as much depth as possible. So, turn the page and have a look at the outline of issues that I've presented. You'll see right away that I have brought up just about every theory of liability that is related to land. Public nuisance, private nuisance, strict liability, negligence, even trespass to land, and then I reach a conclusion. Now, as we consider public nuisance, the first thing that we've got to discuss is Howard's standing to sue, because ordinarily some citizen who is in a community that is subject to a public nuisance doesn't have standing to sue. The community has to sue by an administrative agency like a city or a local government must sue. But where the local authorities won't sue, a private individual can bring an action for public nuisance if he or she has suffered a specific harm that's different from the harm everybody else suffered, not just more of the same. And here, since only 4 homeowners suffered burnt lawns, and this guy Howard is one of them, he does have standing to bring a public nuisance action. Now, how do we judge a public nuisance? Take a look at the balancing test. And here, you'll see in my outline, I'm using the facts as an organizing principle. The law here is very simple, and where the law is simple, and where we only have one lawsuit, our job is to find a home for as many of the factual details as possible. And although the multi-state doesn't call on us to recite facts or to connect them with elements in an essay, exactly those skills are required to make a decision between the best answer and all of the others. So as we consider the balancing test, we know that zoning permits a smelter in Zone A, and we also know that these communities have basically come to the nuisance, that the smelter was around for years before these communities were. But to establish a public nuisance, to my way of thinking, the facts that will tip the scale in favor of Howard is the permanent threat to the water supply. We'd characterize that as an irrevocable harm, and that's something that we're not going to stand up for. At least we're certainly not going to stand up for it at the time of establishing the theory of liability. Howard has established a public nuisance, and the same basic facts that he uses to allege his public nuisance claim also are enough to establish a private nuisance claim, although obviously he's only got to establish nuisance once in order to be entitled to remedies. With regard to strict liability, here we focus narrowly on the toxic chemicals, both the ones that were blown onto the plaintiff's land and also those that are going to be buried and have been buried and pose a threat to the water supply. Certainly, a defendant could expect to be held strictly liable for that kind of injury. With regard to negligence as a theory of liability, here we focus in particular on the incident that resulted in the burned lawns. And I would suggest that the way to establish a breach of duty would be through res ipsa loquitur, because at no time did the plaintiff have any contact with the instrumentalities that caused his injury up until the time he was hurt. At the entire time, the defendant was in control of the truck and the chemicals, and the fact that a lid was allowed to blow off of one of these containers really wouldn't happen unless somebody was careless. So it's almost certainly enough to establish nuisance. Next, we turn to trespass to land. This might strike many of you as being a tertiary theory, or maybe not even applicable at all. But have a look. The plaintiff could conceivably bring an action for trespass, although you'll notice I put it last, and I don't spend a lot of time on it. But certainly, this plaintiff would argue that his land has been invaded by the toxic chemicals. The problem is, although the defendant did deliberately transport these chemicals, the defendant did not deliberately spread the chemicals on the plaintiff's yard. And so I would argue that the plaintiff would not really be able to establish the correct intent in order to establish a claim for trespass to land. But one reason why a plaintiff would allege it is this is the only theory of liability alleged that could conceivably result in a grant of punitive damages. So I would conclude that this plaintiff has certainly established his nuisance claim, and he probably can establish strict liability and negligence with regard to the chemicals. So we know from the call of the question, or actually from the paragraph before the call, that this plaintiff is looking for damages and he's looking for injunctive relief. So we consider the damages that he has suffered, and here we see again that the better you know remedies, the more you've got to say about a question like this. The damages for nuisance would be based on one of two formulas, either the cost to repair or the diminution in value. And theoretically, the same damages calculations would go for all of the different theories of liability except for trespass, because if the plaintiff can prove trespass, the plaintiff can get punitive damages as well. Now, to my way of thinking, intent is lacking, therefore the plaintiff can't prove trespass. So with regard to damages, certainly the plaintiff is entitled to damages. But that's not what he really wants. What he really wants is equitable relief. And here, all we need to do is rehearse the elements of equity and consider the facts in conjunction with each one of those elements. Are legal remedies adequate? Answer, no, because real property is unique. And by the way, when we look at cases in contracts or in real property involving equitable relief, one thing that we're going to see across the board is that because land is unique, almost any dispute involving land, whether it arises in torts or contracts or property, can be enforced via equitable remedies. Because land is unique, therefore damages typically are inadequate. Would it be feasible for a court to issue a decree either to abate the nuisance of the noise and the dust or to require that the chemicals be buried in some other fashion? Answer, yes. Balancing the hardships is a more difficult question. And remember, when we reviewed this black letter law, I indicated that oftentimes we have to do two balancing tests, one to establish the nuisance and then one to decide whether or not equitable remedies should be granted. Now, it seems to me, although presumably the community benefits in many ways from having an employer like this right in the neighborhood, the threat to the water supply, to my way of thinking, is the determinative factor. I'm not going to allow this refinery to destroy the water supply. Almost anything else I think could be compromised, but not that. So, as we consider balancing the hardships, I find in favor of the plaintiffs with regard to the buried chemicals. On every other point, I think reasonable people can probably differ. And as we think about the court's role in resolving this dispute, the court has a responsibility to think beyond the parties and to think about the greater good of the community. And here, balancing the hardships doesn't just mean balancing the hardships between this plaintiff and this defendant. Since the issue is public nuisance, the court is going to consider the general strengths and weaknesses to the community of an issuance of equitable remedies. It seems to me ultimately that the refinery doesn't have any strong defenses, particularly with regard to the toxic chemicals. As I say, just about everything else, reasonable people could differ and could write reasonably strong answers. So, taking a step back, here we've seen a fact pattern which is not incredibly elaborate, but which does give us a chance to rehearse most of the tort theories of liability that have anything to do with land. And that's why understanding how the theories relate to one another is so important. We see a cluster of issues related to land, and the examiners can see it too. That's why they've tested just about all of them in this one fact pattern.